Please, my lord.
Yes.
I'd like to mention item number 18.
18.
18. The leading counsel is unavailable to come today as he is having some personal difficulties. As he is having some personal difficulty.
Who?
K lawyer, the leading counsel. So, may be adjourned for that.
It is listed for orders.
For that,
What is to be done? We'll see.
on the last occasion, the Honorable Court has passed to take fresh steps against the respondent number 2 and 3.
So you have taken this
Yes,
step.
sir.
We'll see. Wait for your turn.
One more item, I'd like to.
Yes.
Item number 8.
8.
The leading counsel is out of it. Mr. T. Gamble. So, may be adjourned for that. You can make it.
On the prayer of Mr.
M. Rathabali.
Learned Counsel for Swensa, Learned Counsel for Learned Counsel appearing on behalf of Mr. D. Kamdal. On the ground of Mr. D. Kamdal, Learned Counsel for the petition is out of the station. Come on. Let this matter be listed after 3 weeks.
Your Lordship, may I mention item number 25?
25.
Yes,
Yes.
I am for the respondent here.
Yes.
Conducting counsel for the petitioner, he comes from other district. So,
On the prayer of Mr.
M. Khambo.
and Kambo, Learned Counsel for
Lordship, my humble request, kindly a fixed date may be given for this matter.
today is fixed, but then if you are not, we'll just adjourn it. On the prayer of Mr. M. Kambo, Learned Counsel for the petitioner,
No, I'm for the respondent.
respondent, list this matter after 3 weeks.
Your Lordship, there is interim. Continue.
Mr. So-and-so is present. Interim order passed, and they shall continue.
Lordship, I have to mention one more item number. That is item number 13 and 14.
13, 14.
Yes. This matter has already become infructuous. The main
Yes, with 13, 14. Yes.
The main petition was CRP 25 of 2024, which was already disposed earlier.
Okay.
My lord, in view of order passing that CRP,
What is that number?
CRP number
CRP 25.
Mr. K. Tama, Learned Counsel for the appellant, and Mr.
M. Khambo.
M. Kambo, Learned Counsel for the respondent,
Yes.
jointly submits that in view of the order passed, or in view of the disposal of the CRP number so-and-so,
25,
25 of 2024,
2020.
the present appeal has become infructuous.
My lord.
In view of the appeal stands dismissed as infructuous. In IA 148 and 149 separately, in view of the disposal of the appeal, so and so, the present IA is also stands closed and disposed of.
Highly obliged.
Lordship.
My lord, may I beg to one mention?
Yes.
Actually, what happened? Item 1. Today's item 1, my lord.
We are dismissing it. You appears to be a rogue litigant.
No,
Totally
there is
uncalled for.
some.
We are dismissing your appeal, this revision.
There is some defective, so we want to withdraw that. So
Withdraw it and you file it again, we'll dismiss it. Go and pay, make a payment. Deposit the.
effort, my lord, is being made, but
It was a consent order, sir.
of course, my lord.
It was a consent order.
My lord.
That's why I'm using the word rogue litigants.
My lord.
Just because you are not able to manage the money, you cannot keep filing the petition. Rather, will impose a cost.
Anyway, my
Not
lord,
only cost,
we'll
will enhance the sentence.
be, my lord, withdrawing. There is some technical defect also.
Advise your client properly.
My lord. We'll withdraw.
We don't expect such client to be, I mean,
Effort is still
take
being
the,
made.
to abuse the process of the law.
Partly payment is made.
Whatever you have to pay, nothing remains there. Sorry to mention that he appears to be a rogue litigant, but in fact he is.
But then, my lord, genuine effort is there. Even to sell the property also.
Talk to them. What's there? You cannot file petition after consent orders.
My lord. We'll withdraw.
Mr. K. Thaman, consent for the petitioner submits that he may be allowed to withdraw this petition.
Item 1.
Prayer is accepted.
Criminal Revision Petition number 20.
Criminal revision petition stands dismissed on withdrawal. Don't file again. Otherwise, serious orders may be, adverse orders may be passed.
My lord, there is but then on judgment, my lord.
We are not stopping the litigants from approaching the court, but they will have to be careful about this litigants.
Effort is being
There is
made.
not
my
a-
lord. Part
interest-
payment is done.
interest.
Now also we are trying.
Whatever you talk to the other party, whatever you want to do, but it's not the, I mean, there cannot be a ground to file, approach the court again and again.
My lord.
It's clearly given. This court has clearly directed on your consensus, consent orders,
My lord.
to pass an appropriate order if fails to
Pay.
comply or deposit. The 20%. So advise your client properly.
Highly obvious.
Better be away from the court. Rather, otherwise he may be in trouble. Maybe in hot water someday.
Highly obvious.
My lord, I would like to mention item number 22 on behalf of leading counsel, Mr. D. Boje. Currently, he is out of station.
Which one?
Item number 22, my lord.
22, what remains there?
Yes, my lord.
Nothing remains there. What is this? Adjournment after
The
adjournment.
whole thing is in fact misconceived. No appeal lies.
You argue the matter. We are granting a time till tomorrow.
Tomorrow. Your Honor, matter may be listed after 3 weeks.
No 3 weeks.
After that, I cannot.
It takes hardly 1 hour to go through the brief.
Yes, I went through, my lord, but I'm like,
According to what is there? Is there anything to be?
actually, my lord, I
determined?
can't understand what is written there, so I have to go properly again.
When did you join the bar? When did you join the profession?
Profession, it's almost like 1 year, but like I skipped the practice.
Is it written in English or something else?
English?
Petition is written in English. Then any big words or very highly, I mean, sophisticated words are being used in the petition.
Yes, some words.
We have a Google, we have the dictionary, we can. We'll assist you. You argue the matter tomorrow.
Tomorrow, my leading counsel will be here, so
We don't need your leading counsel. We want to hear you. Your senior is there. He'll assist. He'll help you out.
Okay, my lord.
2017 method. There's nothing. What is to be done?
After 3 weeks, my lord.
We'll make it 6 weeks.
They might be enjoying an interim order, I don't know.
Let us see. Item 22.
there was a fine imposed for assault.
Hmm.
So the proceedings are under the criminal side of the 1945 regulation.
Hmm.
No appeal can lie to the High Court. If the only if there is a sentence for imprisonment up to 3 years, then only an appeal lies. The order of the village authority is also not annexed. But from the synopsis I get, for assault, the fine has been imposed.
So many adjournments.
There is another matter with my learned friend, that is from
So
2014.
it's true, prima facie, it's, I think appeal is not maintainable. Anyway. On the prayer of, what is the problem with Mr. Boje?
My lord, he is out of station.
But even if he is here around, he used to make a mention for adjournment all the time. At least before this court, I don't know.
I'll inform him the message.
Tell him, apprise and inform him that why you are not interested to argue the matter before this court. Is there something wrong? Or should I recuse from the case? Should I recuse from the case? Yes.
No.
Tell him,
Okay.
tell Mr. Boje that next time if it is listed before this court, court may recuse from the case. Tell him. If there is something wrong,
Yes, Your Honor.
if there's something doubt in his mind,
Okay, my lord.
okay. On the prayer of Mr. MS. Your name, please.
Aryapu.
Aryaku, learned counsel appearing on behalf of Mr. D. Boje, learned counsel for the appellant, and the prayer not being objected to by Mr. D. Pangi, learned counsel for respondent. List this matter after 4 weeks. List of. It is made clear that no further adjournment shall be allowed
Lower court.
on the next date. After 4 weeks.
Thank you, my lord.
Obliged.
Please, my lord.
Yes.
My lord, this is bail application under 483 of PNSS.
Hmm.
Kindly issue the notice.
Okay.
So any
So
sort
you don't want to be released on bail, only you want notice.
No, I want to be, my lord.
Then,
My lord, the basic allegations, that is page number 1. The second para, basic allegation
not
against
Mr. So-and-so, learned counsel for the applicant,
no bail applicant.
next para. This application is filed under section 483 of BNSS 2023, praying for grant of bail to the accused person, namely Sri Sukhdev Das, in connection with cyber crime PS case number 54 of 2024 under section 1111/319 of BNS 2023, read with section 66, bracket, capital D, bracket clause of IT Act, comma, who has been arrested on 06/11/2024. Call for the case diary. Call for the second copy of the case diary. MS, next para, MS Elhage London additional PP. Appears for this state. List the matter after.
My lord, any short
After-
that may be given.
After a week.
Obliged. Yeah, please, your lordship.
Lordship, this is an anticipatory bail application, Lordship. Allegation against me is a sexual harassment, Lordship.
Very serious.
Lordship, section 75, 78, 79 is alleged against me. But Lordship will see that plain reading of the
Has the situation been calmed down in the campus?
a little bit, Lordship. It has come down a bit.
You appear, what's there?
Lordship, they have issued, the police has issued.
That's why
notice.
you are not appearing? You appear.
Lordship, may kindly see the reply that we have furnished to the IO of the case, which is at page.
It's hard to believe that the informant was the one who has approached you.
Approached me
Well,
for
we'll see-
preparation of PPT.
We'll see the case diary. We'll call for the case diary.
Lordship, interim, since Lordship, I'm ready to cooperate with the investigation, Lordship.
Obviously,
Since
you have to.
immediately after the incident, I was brutally beaten up, Lordship. May kindly peruse the medical,
That's why I would
medical
like to see.
prescription.
This matter is very serious. On next day, we'll consider. All right. Where he is now? Is it the campus?
No, he has left. There is a review committee report by the institute whereby the committee has taken a decision to expel him from the institute. He has been expelled. So he has left the campus and he's in his hometown now.
That's the whole problem. Even if we grant you a bail, you have been expelled, you are not in the station, it will be very difficult. It may impede the investigation.
No, Lordship, I'm ready to cooperate with the investigation.
We'll see. Where are you now? You are a permanent resident of?
Bihar, Lordship.
We'll see.
I'm a fourth year student, Lordship.
I know. I've seen it.
I'm in verge of completing my course. So there is no chance of flight, Lordship.
We understand. But then situation is as such. Had you been continued in the hostel or somewhere else in the state, would have granted you bail for the interim. Otherwise, we're not saying that you are not entitled. We'll consider, we'll see the CD. And it indicates also that since you have been expelled, there must be some privacy case.
Lordship, expulsion was out of the protest that was taking place in the campus. So the committee.
Yes, madam.
So city may be called for no intermediate state lordship.
Why?
Okay, because this is serious nature lordship and more and the possibility of the lordship some kind of influence can be lordship because as such kind of cases lordship it should be very strictly followed by the lordship. This court may lordship take strict action lordship because lordship once lordship is statement lordship recorded lordship he maybe seems to be cooperated now lordship but after that lordship he is from the outside lordship. We never know lordship, what will happen. Lordship.
Number one is personal liberty.
Lordship.
Number two, before he's proved his guilt, he appears to have been punished.
Lordship, that's why lordship is not it's a not conviction lordship. This is lordship CD may be called for lordship.
I know. Expulsion is not a conviction.
Lordship.
But then it amounts to a penalty again.
Lordship.
See, look at his career. It's all ruined.
Lordship, interim protection of lordship. In other cases, it can be understood lordship. It's such kind of cases lordship. Court may show some strict lordship.
You cannot tell us in other cases we should grant bail and in such a case we should not. We'll see on the basis of it. We'll see.
Lordship, I'm ready to cooperate, Lordship.
After 1 week, we'll see.
Can it be on second?
Can you bring it on Friday? CD.
Next Friday, lordship.
This Friday.
Lordship, this Friday. I'll try lordship.
No, so we'll fix it on Monday.
Lordship.
Monday.
No interim today. Right?
Right.
And Mr. J.G. Learned counsel for the applicant. Next para. This application has been filed under section 482 of BNS 2023. Praying for grant of praying for privilege of pre-arrest bail to the applicant in connection with Eternal Women Peace case number 60 of 2024 under section 75, 78, 79 BNS 2023. Call for the case diary. Scan copy of the case diary. MS L. Hage, Learned additional PP. Please for the state. Listed matter on, when is the Monday?
Second.
Second,
Second.
02/12/2024.
Public.
My lordship, this is a joint petition filed by the accused.
What
That
is the
is,
offense? What is the offense?
offense is 448, 427 and 324.
Compromise.
Yes, party has been settled, your lordship. In fact, your lordship, during the framing of charge, the section 324 has been dropped by the learned trial court. I have annexed the order.
324.
Yes. In phase number 50.
Will call for the scan copy.
Yes, Your Lordship.
Or Mr.
P. Bhate.
Learned counsel for the petitioners. This is the application under section 520 BNSS 2023. Praying for quashment of the criminal proceedings of GR case number. What is that?
GR 260 of 2019.
60?
260
260 of
oblique 19.
2019. Under section 448, 427, 323, 34 IPC. Pending before the judicial magistrate first class.
Coloring, yes, lordship.
Magistrate first class. Coloring.
Yes.
Call for the scan copy of the trial court record. Mr. MS TG Learned additional PP appears for the state. Next para. Pending production of the trial court record. Further proceedings of GR case numbers 260 of 2019. Before the learned judicial magistrate first class colonial still remains.
Hey, your
Still
lordship.
remain state.
Yes, in interim stay.
List after 4 weeks. Huh?
Stay, your lordship. Interim stay. May be.
Please, Your Lordship, this is a joint criminal petition filed under section 258 of.
Heard MS A. Thalam,
Yes, Your Lordship.
learned counsel for the petitioners. This is an application under section 528. Praying for quashment of criminal proceedings of GR case number 45 of 2023 under section 447, 426, 500, 510, 290, IPC. Pending before the
Judicial Magistrate First Class Inkyong, Your
judicial
Lordship.
magistrate first class in here on the basis of the settlement between the parties, between the petitioners. Call for the scan copy of trial court reports and so on. MS TG learned additional PP and appears for respondent state. Next para. Pending production so and so. Further proceedings so and so so and so. Still remain in state.
Here, Lordship, we are not denying the liabilities, Lordship. Entire 25 lakhs, which was due, Lordship, It's a check bounce case, Lordship. We have
NIA.
NIA, Lordship. We have paid back, Lordship. We have the records, Lordship, in our records, Lordship. Before arrest, I have paid some amount. After arrest, I have paid the entire amounts, totaling 25 lakhs, Lordship.
Hmm.
Now the
What
proceeding
what
is
the
still
law what the
continuing.
law says? On payment, are you automatically get absorbed from the charges? What the law says?
Lordship, normally they are discharged from the charges, Lordship.
Yes. So as any law,
Lordship, today I
will
I
simply
don't.
will issue notice. Will issue notice and call for the scan copy. We'll see.
Lordship, I'm being agreed by the impugn order, Lordship.
Yes.
Whereby, Lordship, time and again, Lordship, initially non-bailable arrest warrant was issued, and again, bailable arrest warrant was issued, Lordship.
You are not cooperating in the trial.
In fact, the pleader is appearing on my behalf, Lordship.
Hmm.
Now, this is a semi-criminal case, Lordship.
Hmm.
In such cases, Lordship, there are citations, Lordship, where it says that appearance of the alleged accused is not mandatory, Lordship.
So that's what I'm saying. You just show us a law that on your even after the dishonor of the check, if you fail, if you make the payment, you automatically entitled to be discharged. What is the law? That is what you are thinking. What you are saying. Am I correct
Lordship.
or not correct?
Lordship, you are
I
correct,
just
Lordship.
wanted to know from you. What is the stage?
Lordship, now the learned court below, Lordship,
Hmm.
is saying that since I am not appearing before his court, he has issued bailable arrest warrant of 10,000 rupees against me. Impugn order is page 85, Lordship. Now the matter has been fixed tomorrow, Lordship.
You appear tomorrow.
So it is fixed for necessary order. It is fixed for necessary order, Lordship.
You may be discharged tomorrow also.
Lordship, I am instructed that my client is suffering from various elements,
No,
Lordship.
that cannot be ground to stay the proceedings. That you have to file an appropriate application before the
We have filed, Lordship.
magistrate. You are with that.
Last time we have filed, Lordship. It's clearly reflected in the order also, Lordship. But the learned court below has failed to consider.
Where is the impugn order? Let us see.
Page 85, Lordship.
85.
J.
Hmm.
Lordship, I am reading, Lordship. Complainant is represented by learned counsel A. Gamre. Accused person Gopal Chandra Das is absent. Learned counsel for accused person D. Sora present. Learned counsel for the accused person has filed daily petition number so-and-so on the ground stated therein. The prayer for dispense is objected by the learned counsel for the complainant on the ground that the accused person has not made any payment after the previous date and is deliberately delaying trial of the case. Third, since the prayer for dispense was allowed on the previous date with the direction the accused shall be present today without fail. Also, since the medical documents enclosed with the dispense application does not state the accused is incapacitated, bedridden. In view of the above, prayer for dispense is hereby rejected. Issue bailable arrest warrant of rupees 10,000 against the accused person for deliberately not cooperating with the trial of the case. Notice to surety fixed for necessary orders on 28/11/2004. Yes. Complainant shall take steps. My medical prescriptions, Lordship, it was filed along with
No, this is for quashing of the entire proceedings.
No, sir.
You are not challenging this by this petition.
I am challenging this order as well as the entire proceedings also.
We simply will issue notice. You, whatever you want to do, say before you appear tomorrow and you say whatever is to be done tomorrow, whatever order first, you may come back again. But since the matter is fixed tomorrow. All right. Heard Mr. Jejini, then counsel for the petitioner. This is an application under section 522 of BNS 528 of BNSS 2023. Praying for quashment of complaint case being CR case number 661 of 2022 under section 138 of Negotiable Instrument Act. Pending before the Chief Judicial Magistrate, UPR. I think there is a dispute. He is claiming 25 lakhs. You are saying 16 lakhs. You have borrowed 16 lakhs, right? But he is claiming 25 lakhs. So, in a strict sense, you cannot say that you have made the payment.
Check
Check
amount
was of for what?
25 lakhs.
You have not paid 25 lakhs.
Lordship, we
You
have
have paid 25.
already paid.
You place everything before the magistrate. Tomorrow also you do that. All right. But with the supporting law that on the payment of the amount, whether you will be entitled for the chairs. Appear tomorrow. In any consider if any order is passed, you may come back. Nobody is stopping you. All right.
All right.
Issue notice returnable by 4 weeks, 3 weeks. List of MS L. Hage, London additional PP, appears court. Listed. Petitioners take steps for solution notice upon response number 2. By registered for so and so, so and so. Call for the scan copy of the price report. List after 3 weeks.
Obliged. May I please, Lordship?
Yes.
Yes, Lordship. This is an application for quashment of POCSO case.
Yes.
Lordship. Whether on the last occasion, trial court record was called for by this honorable court.
It's here.
Okay.
Dismissed. Petition dismissed.
Lordship, one submission.
Yes.
Lordship, the statement of the victim was recorded. Lordship may kindly peruse.
Where it is. Have
Then-
you annexed it?
No, I have not. It may be in the trial court record. The statement of the victim has been recorded and
You
as
find
per,
out, madam,
as per
statement of the victim.
her statement.
Before the court.
Yeah, no, yes, before the court, during the proceeding, before the trial court.
What is
And-
the stage?
This is in a stage of evidence.
Yeah.
And the victim is the only witness who has stated that she was subject to rape.
Obviously.
Yes, of course. But it is not even been substantiated by the expert evidence. There is medical evidence. Because her medical also was not been done in this case. Medical examination has also not been done
Yeah.
of the victim.
It's a matter of trial.
Yes.
You
But
push-
then now the victim says that she was not raped. So, honorable court may consider, that is just my submission, upon perusal of her statement. Beyond that, I have nothing to submit, Lordship. Because tomorrow, if this case goes for trial also, there is no any chance of conviction.
We don't know.
I think, Lordship, that is 161 statement, but I am referring with regards to the evidence which the victim has deposed before the trial court.
Lordship, it is there.
That may be in the trial court.
Before a special judge,
Yes, Lordship. POCSO.
there's no statement. It's only before the magistrate.
The one.
No.
Case report.
No. This is only before the magistrate.
Lordship, that's all.
Only before the magistrate, no other statement. Find out. This is only, that is first one is, flagged one is JMFC, magistrate. No, let him find out. Let her find out, sir. Not by you.
Done as public prosecutor for production of trial court record. So if it is before this honorable court, then we may
FIR is at page number 27 also. Type copy. It is to inform you that I caught two persons red-handed at around 8 a.m. today on 23/3/2022 at BSNL BTS mobile tower map while they were attempt to steal BTS material. A motorcycle bearing registration number so-and-so was at the spot which they brought along with them. First, I observed them as they were dismantling the feeder cables, climbing on the tower, and when I approached them, they asked them about what they are doing. They said they were being sent by BSNL officers. While whole matter was taking place, one more person came up to the spot which was being called up by the red-handed for 2%. Therefore, I request your kindness register FIR against 3% involved in the incident. Thereafter, Lordship FIR on receipt of FIR, the Savali police has filed charge sheet against 3 accused persons and the 3 accused persons. And the matter has been, the charge sheet has been forwarded before the learned Court of Chief Judicial Magistrate UPR. Lordship, so far, none of the prosecution witness statement has been recorded by the trial court. So, during the pendency of the present case, Lordship, the alleged accused person, they have settled and compromised the matter with the informant who has filed the present FIR. That is page number 70, annexure 6, by an agreement dated 12 February 2024. And now, basing upon this agreement of settlement, the accused persons came before this honorable court for Quashment of the present case.
Yes, madam.
Your Lordship, the only objection we had made was that since the property that was dismantled and the attempt was made, Your Lordship, he is just a caretaker, Your Lordship. The agreement has been made with the caretaker and the accused, Your Lordship. Our only objection is that since it's a BSNL, it ought the agreement, if any mutual agreement, it ought to have been with the party, BSNL party, Your Lordship, be the head of the BSNL or who is the in charge, Your Lordship, not by the caretaker.
What is the property was stolen?
No,
To take it away?
No, it was dismantled and there was an attempt to take it away.
Dismantled?
Yes,
It has not been taken away.
not taken away.
How does it dismantle? What the extent of damage? Is there anything?
Lordship, if I may allow to submit then. Lordship, regarding the dismantling.
Your Lordship, if come to
nothing.
page number 32, Your Lordship.
Yes, because if there is anything related to dismantling of property, definitely
Which
section.
are used for stolen transportation is estimate which is from the spot. How old you are? Accused is, what is the age of the accused?
Lordship, they are around 21 years, 24 years. They young, 23 years, Lordship. They're very young. young boys. Lordship, had there been any dismantling of public property, definitely section 3 of PDPP could have been attracted and the police could have registered, filed charge sheet under section 3 of PDPP Act. But here in this case, during investigation, nothing of that sort could have been established by the police. It's just an attempt. The property was not even stolen by this accused person. And there is no any criminal record against this accused petitioner. This was the first time offense. They were young boys. Lordship.
Lordship,
Hmm.
I have a small objection with regard to, even though I may have to the extent of technicality, Your Lordship.
Yes.
However, Your Lordship, if Your Lordship will see the signature in the FIR, Your Lordship, which is at page number 26.
Yes.
That's an initial, Your Lordship, page number 26.
Hmm.
It's completely different to the signature in the affidavit, settlement affidavit, as well as in the authority letter to file this petition, Your Lordship.
Hmm.
Your Lordship will see, I'll show all the signatures starting from page number 19.
Hmm.
First is Teli Nega, Your Lordship. Page number 20, Your Lordship will see. It's a complete different, Your Lordship. Then at page number 26, page number 26, Your Lordship will see.
There's three accused.
Yes,
Three accused persons.
And yes.
Hmm. So there's no separate affidavit. It's only a authority letter.
Yes.
Huh?
Yes, Lordship.
You file an affidavit. Who has signed the affidavit? Yeah.
Yes.
Group Peter.
No, three accused person, they have filed affidavit. Accused person, they have filed affidavit, three different affidavits.
Where it is?
Page number 16, 17, and 18.
Okay.
The complainant has not. filed
Whatever
this.
the complainant,
Complainant has given authority.
that's what I'm saying. You get the affidavit of the,
Lordship,
get the affidavit of the,
of complainant.
hmm.
Will do it. If required.
Petitioner number 2. Petitioner number 2.
No, Lordship. He is not the petitioner. Complainant is not the petitioner.
No, 2 years.
Yes,
Daily
yes,
negation.
Lordship.
Yes.
Yes, yes. He has not filed affidavit yet, but he has given authority.
You file an affidavit.
Okay.
And she has also made a complaint that the property, the owner of the property, which has been dismantled, is not a party to the settlement.
Property was not dismantled as per FIR, as per charge sheet. It was just an attempt.
No, charge sheet has been filed, whatever is there.
Charge sheet, in the charge sheet.
You
Lordship,
get the settlement with the BSNL also,
Lordship,
BSNL
in the
authority.
entire prosecution history, BSNL is nowhere, none of the officials and officers of BSNL has been examined and accorded the same. Nothing has been mentioned in the entire
It's
prosecution.
mentioned. You see the charge sheet.
In the witnesses, none of the prosecution witnesses has been mentioned.
Even
They just
the.
said that it's a property of BSNL. But
Lordship.
none of the officials and officers of the BSNL has given a statement to the effect that the attempted property for stolen was belong to BSNL.
Yes, your lordship will also see the informant has been bracketed as site caretaker, therefore an employee of the BSNL, not in his jail capacity.
Caretaker.
Yes, site caretaker, your lordship.
It's okay, forget it. Nowhere it has been, charge sheet also doesn't say
Yes.
any property of the BSNL. Feeder cables by climbing on a BSNL tower at May Village and attempting to steal BTS being at BSNL tower and stealing over when they were water rated. Feeder cables of BSNL tower.
Yes,
You take affidavit from BSNL authority also. Or else you have an
BSNL
agreement
authority,
with them.
They are completely unaware of the incident because nothing has been.
See, it is on the basis of compromise. So we want to would like to allow your petition, do something, do your job, get it done.
Regarding the affidavit of petitioner number 2, we can obtain lordship. But regarding, because BSNL authority, they are unaware of this incident because nothing has been lost. And they were not unaware.
But on investigation, you have found and you have admitted that
it was an attempt. And regarding the damage of the property also in the investigation, nothing of that sort could have been established by the
it's up to you in that case. She will have the same objection on the next date. Had Mr. Titaba learned counsel for the petitioners. Also MS, also heard MS easily learned additional PP for district. After hearing the counsel to the parties at some length, it is noticed that the petitioner number 2 has not filed an affidavit in support of this present petition. Is the informant in the case. Considering above, then counsel for the petitioners is granted further 2 weeks time to file an affidavit on behalf of the petition number 2. List after 2 weeks.
Yes.
Case records be retained.
Yes,
It
Your
will be with you or
Lordship.
in
No,
the court?
the registry, Your Lordship, leave the court.
Case registry to retain the case records.
Dep-
Depot. Yes. May I please?
Yes.
Sorry. This is also, Lordship, an application under section 482 of CRPC for passing of FIR and charge sheet in connection with Chimpu PS case number 47/2021. The allegation against the accused person is under section 380 of IPC, that is theft in a dwelling house. Lordship. Lordship, here in this case also, Lordship, the accused persons and the informant victim has already settled their matter outside the court, and they have filed a joint affidavit, joint agreement that the matter has been settled outside the court, and now they are coming before this honorable court for quashing of the present case. Lordship. The allegation against the accused person was that the accused person has stolen their motorbike on 23rd December 2021 from their parking area of their house at Gopur Jew Road, Itanagar. After registration of this FIR, the police has investigated the case and found a prima facie case. Thereafter, they have filed a charge sheet before the learned Chief Judicial Magistrate Court, UPR, and Lordship, section 379 IPC, that is theft. The charge under theft was well established against the accused person Dinesh Musari and Pelin Verma, 2 accused persons. Then Lordship, they have jointly settled the matter, and all of the 3, that is 2 accused persons, petitioner number 1 and 2, they are accused person, and petitioner number 3, he is the informant victim whose motorbike has been alleged to have been stolen by these 2 accused persons. He also came before this honorable court and filed his affidavit for passing of this present case.
How can they file how can they make an agreement for quashing?
Lordship.
They can settle their dispute, whatever is there. But they cannot file enter into an agreement.
Yes, Lordship.
Yes, madam.
Yes, Your Lordship, I don't have any objection, Your Lordship, since also the bike has been recovered, Your Lordship.
Heard Mr. T. Taba, learned counsel for the petitioners,
Yes, Lordship.
and also heard MSTs in learned additional PP for the state. By filing this application under section 482 of CRPC, 482 CRPC, the petitioners have jointly prayed for quashing of the criminal proceedings of GR case number 1227 of 2021 under section 380 public 34 of IPC pending before the Chief Judicial Magistrate, UPR. On the basis of the settlement between the petitioners. Next paragraph. The prosecution's case, the case set up by the prosecution is to the effect that on 24/12/2021 at 19:22 hours, a written FIR was received from Wansiri Chelo Taka alleging that on 23/12/2021 at about 3 a.m. his motorcycle within bracket Yamaha R-15 B small b second B capital B 3 black color bracket clause bearing registration number AR 15 public 2831 has been stolen by some unknown miscreants from his rented house parking place. List of next para. On the receipt of the said affair, a case was registered by officer in charge police station Chimpu, being Chimpu PS case number 47 of 2021 under section 379 IPC. Next one. During the investigation, the the petition number 1 and 2 were caught. Accuser were 1 and 2.
Yes.
Accused persons. Petition number 1 and 2 were caught with the stolen motorcycle from their possession. Mr. Accordingly, they were arrested and the stolen motorcycle was seized from their possession. Then possession, Mr. Thereafter, the motorcycle was given on Jimma to the owner of the said motorcycle, the Sri Chelo Taka, within bracket informant, comma, petitioner number 3 hearing. Is it petition number 3?
Yes, Lordship.
Yes.
Mr. It is recorded by the investigating authority that the petition number 1 and 2 have accepted that they have stolen the said motorcycle. Mr. Next paragraph. After completion of the investigation, the police has filed a charge sheet on section 379 oblique 34 IPC against the petition number 1 and 2. Mr. Charge sheet has been filed.
Yes,
So the charges have been framed.
yes.
Thereafter, the London court below has framed the charges against the petition number 1 and 2. Next para. Mr. T. Taba, London counsel for the petitioner, submits that although as per the report of the police, charge sheet of the police, the petition number 1 and 2 have said to have admitted the guilt. However, during the pendency of the proceedings, the parties, the petitioner number 1, 2, the petitioners have entered into a deed of agreement on 07/05/2024. And have settled the matter amicably, with a mutual understanding that they shall maintain cordial and amicable relationship with each other. Therefore, he submits that even if the criminal proceedings is allowed to be continued, there is no chance of the chances of conviction are bleak. Mr. And as such, the praise for quashing of the present, the quashing of the criminal proceedings being processing of GR case pending before the judicial magistrate. Chief Judicial Magistrate.
Yes, Lordship. UPR.
UPR. Mr. Next para. MST in additional PP for the state in her usual fairness submits that since the motorcycle has already been recovered and handed over to the petitioner number 2 within bracket, whose motorcycle was stolen by the petitioner number 1 and 2. And the petitioners have entered into a settlement, comma. No useful purpose. I mean, the chances of conviction is remote. Therefore, continuance of such proceedings may be abuse of the process of the law. Accordingly, therefore, she submits that in the circumstances of the present case, an appropriate order may be passed by this honorable court. Next one. I have considered the submissions of the land council for the parties, and also where is the trial court reports. Next paragraph. It reveals from the record that the petitioner number 1 and 2 have admitted that they have stolen the said motorcycle. Mr. Howard, the said version is being made before the said statements is being made before the investigating authority, made before the police. Mr. Have they been examined in the court?
Not yet, Your Lordship, as
Okay.
per
Mr. The motorcycle, the stolen motorcycle has already been recovered and has been handed over to the owner, I, that is, I petition number 3. Mr. The parties, the petitioners, next para, by deed of agreement dated 07/05/2024, have entered into a settlement thereby settled it, wherein they have settled the matter so as to maintain cordial and amicable relationship with each other in future by involving the family members, Mr. Having considered the above fact situation, I'm of the view that continuance of such a proceedings, the continuance of the present criminal proceedings before the court would be would not serve any purpose as the as in view of the settlement between the parties. There may not be, and no evidence could be gathered for, no evidence would be extracted during the proceedings to establish the guilt of the accused persons. In other words, the chances of conviction appears to be far too remote. Does such proceedings. There's allowing the such proceedings to continue would be abuse of process of law. Where no conviction could be obtained. Mr. Next paragraph, having considered the matter in its entirety and on its attending facts and circumstances. I'm of the view that the criminal proceeding of year case number so and so is deserved so and so under section so and so pending before so and so, warrants interference by this court by invoking the power under section inherent power under section 482 of CRPC. Accordingly, the criminal proceeding of GRC and so and so is hereby what's the petition stands allowed. Trial court records, send back the trial court record. It's an original, or we need to change, send it back.
Since it's a scan copy, Your Lordship.
In that case, no need to send it down. Yes.
Yes, this is also a criminal petition for participation. The public hearing is number 16 of the 2019, under section 143, 148, 149, and 324 facts. The prosecution kindly come to page number 21. This is a copy of that file.
121.
121.
Oh,
21.
21. Yes.
On 13th April 2019, at around 11:30 AM, a group of anti-social elements comprises of more than 300 persons led by Sri Gumke River, Gandhi River, so, holding an iron rod, hammer, and other fully equipped with small arms, iron bars, dowels, knives, and other lethal weapons, attacked the female victim. Meanwhile, the assailants were intercepted and stopped by the woman folks on village, and while doing so, Srimati Puju Mijor and Digyam Mijor were assaulted and grievously injured. One of them in her hand. Attempts were made by the village elders, but went injured. Taking advantage of the situation, even murder attempts were also made to Sri Ripo Mijor, and Sri Michi Lande.
I think similar method has been disposed of.
Yes, very similar. That was criminal petition number 82 of the time.
Out of same election related matters.
But otherwise, effects are very similar.
Time also same. Same time. Out of same election.
We can say election, same area also.
Parties are different. Then in that case, out of the same election related matters, madam,
Yes, Your Lordship.
will allow.
Yes. Yes.
Heard Mr. D. Shekya, then consent for the petition. Petitioners, it's a joint petition. What is the charge sheet?
Page number 22, Your Lordship.
22 to 71 is the last.
Your Lordship will find the effective on page number 26.
26. Same application, so and so, on the basis of the settlement, same. How many petitioners?
12.
Section would be,
1 to 8.
criminal proceedings of JR case number 294 of 2024, under section 143, 146, 149, 324, pending before the Chief Judicial Magistrate, Pasigat. Then the case set up by the prosecution is that on 14/04/2019 at around 1650 hours, a written complaint received from one Sri Tini Ngomle within bracket head GB Hime village of Lower Sivan City to the effect that on 13/4/2019 at around 11:30 hours to 12:00 hours, a group of antisocial elements comprised of more than 200 to 300 persons, led by one Sri Gumke Riba, Heni Riba, Kirmar Riba, Kirmardini, Migzam Taso, Bigam Gulam, and Jarka Doke, holding an iron hammer and others fully equipped with small arms, iron rods, dao, knives and other lethal weapons, attacked Hime village. In the meanwhile, the assailants were interrupted and stopped by women folks of the village, and while doing in the process, one Srimati Piyum Nigyor and Jiagam Nigyor were assaulted and sustained serious injury. An attempt was also made by the village elders. No, an attempt was made by the village elders to pacify, but it went in vain. Taking advantage of the situation, and even a murder attempt was also made to Sri Ribom Nigyor, one Sri Ribom Nigyor and Sri Nichi Ngomle by Sri Kirmardini. Next paragraph. On receipt of the said written FIR, a case being Likabali PS case number 16 of 2019 under section 143, 148, 149 of the 324 IPC was registered. After the completion of on completion of the investigation, the police has filed charge sheet against petitioner number 128. A petition number 1, 2, 3, 4, 5, and 5, 6, and 7, 5, 6, 7, and 8, right? Under section 143, 148, 149, 324 IPC.
करेगा आप फाइल को छोड़ दो हो जाएगा
Charge sheet has been framed.
Now,
The learned trial court has framed the charge sheet. On when?
charge is yet to be framed. Charge is yet to be framed.
Okay. which is the case is pending for consideration of charges before the learned Chief Judicial Magistrate Pasighat. Next paragraph. Where is the settlement? $72. How many petitioners are there?
Total 12 also, 1 to 8 are alleged and 9 to 12 are.
Complainant, informant, complaint, victim and informant and victim.
Informant is already expired.
Okay. During the pendency of the criminal proceedings, come on, the accused, come on, petitioner number 1 to 8 herein, and the victim, public complainant, victims only. Informant has expired. The victim, the victims, comma, petition number 9 to 12 have entered into a amicable settlement. When? It doesn't give any date. 72, 71. Where's the date of settlement?
28/4/2024.
Where is it? Where it is?
Sorry, it's 15/5/24.
15/5/2024. You were in. The parties have decided to settle the matter. The parties have settled the matter to maintain cordial relationship with each other as incident has arisen out of purely election related matters. Next paragraph. Mr. D. Sheikh, learned counsel for the petitioner, submits that in view of the settlement between the petitioners, having considered that the incident had happened due to misunderstanding during the election of assembly
And
parliamentary election. Come on. The criminal proceedings may be first as continuance of such proceeding would be an abusive process of law. Mr. MS TG so and so, same
Yes.
expert. Consider the submissions and peruse the records so and so. You just get this one, same thing. What is there any serious injury?
No.
Obtained?
Even though any.
Nothing as such in the charge sheet, Your Lordship.
Yes, next part. On consideration of the materials on record, come on. It appears that the incident had occurred due to during the assembly and the parliamentary election between the rival political parties, supporters of the rival political parties. Mr. That is also noticed that no serious injuries
Yes, simple injuries.
have been sustained by the victims, except a few simple injuries, which is found in the report. Mr. The parties, on realizing that the incident had happened due to a purely on a misunderstanding during the election and has arisen between the rival political parties, supporters of the rival political parties have entered into a settlement. Mr. Considering above, you just put this para of this few paras of so and so. Having so and so, you just take this. Petition allowed and disposal.
Deep blue. Lordship, this matter has in fact become infructuous, Your Lordship. The accused has been arrested on 7/11/2024, Your Lordship.
In connection with the same.
Yes, same.
case?
The CD speaks about it.
Yes. Pasiat case. He was already arrested in some other case.
This is in connection with Pacific case.
No, last occasion, case diary was there and you were directed to. Place the updated status report along with case diary.
Lordship, it may be fixed day after tomorrow, Lordship.
Why?
Because updated case diary call for Lordship on last occasion, Lordship.
This is the order, last order.
On the last occasion,
It is Lordship. This case diary, Lordship, is on 12th November, Lordship.
Yes.
So after that, Lordship, we have again called for the updated case diary.
Last week only. Just read the order.
This updated status report along with shall produce, Lordship. That's why, Lordship, today we could not produce, Lordship. So tomorrow, day after tomorrow, Lordship.
Damocles order hanging over him.
Lordship,
They are seeking for production.
Whether this.
Once it is production warrant is allowed, you'll be arrested. That's all, nothing else.
Lordship.
This is not a fact. This is a company, this registered company under corporate affairs. Company is not a fake company.
Tomorrow lordship, then lordship, I'll say.
Well, hello, what's there?
Lordship,
He's already said in some other.
only one day lordship. If tomorrow lordship permit, then I have no problem. At least lordship case diary should
Civil matter.
produce lordship.
I'm suffering.
Heard Mr. T. Tapak, learned counsel for the petitioner, the applicant. On the prayer of MS L. Hage, learned additional PP. List this matter on
Tomorrow.
To tomorrow lordship.
28.
20.
28,
Yes, sir.
28, 11, 20, 24 for granting bail
For update case diary lordship.
for updated case diary.
Much obliged, lordship.
Updated case diary or what? Should be
Case
what?
diary. Updated case diary lordship.
Updated status report
Lordship.
along with case
Case
diary.
diary lordship.
Not miss it tomorrow.
Well, Lordship,
Yes,
Lordship, we have received the permit.
yes.
So this matter may be fixed for admission here in Lordship.
Your lordship, this appeal against the acquittal, your lordship.
Yes.
Notice,
Notice complete.
not,
Yes. So what is to be done? What if you are for
I am for petitioner. Appearing on
this is appeal against acquittal.
acquittal, your lordship.
Whether this accused have been sub notice.
Therefore, your lordship.
Ah. Yes, what's to be done? It doesn't indicate anything whether the notice has been served on the respondent. Yes, what do you say?
Your
Lordship,
lord,
this matter may be fixed for admission here in Lordship. Yesterday we have received a paper book.
No, whether notice has been served upon the respondent or not, that is what Oh, respondent number, somebody has filed a wakalat number long time back. Which you are for? Only pertain case aksena or el tungon.
I'm appearing on behalf of Mr. D. Pang, Lordship.
Heard Mr. So-and-so learned counsel for the opponent and also heard MS T. learned additional PP. For the state. Non appears for the respondent number 1. Although a wakalat number has been filed on behalf of respondent number. A power has been filed on behalf of the respondent number 1 being represented by Mr. T. Pertin, learned counsel, along with his associates. List the matter after 2 weeks. 2 weeks.
yes, your lordship.
2 weeks for admission. For admission. We'll complete the orders. Running, Yes, it is set for what?
Today, my lord, he respondent, my lord, is, I believe, in inter-appearance, my lord.
2 and 3.
2, 1, 2, 3, my lord.
Okay. Heard, Mr. Learned counsel for the appellant. Mr. Next one, Mr. Elper Learned counsel enters appearance on behalf of respondent 1, 2, and 3.
No, my lord, I am for appellant, my lord. I
Okay.
believe, my lord, he is entering appearance for my lord respondent.
Then in that case, Elper heard Mr. Elper Learned counsel for the appellant. Mr. K. Gao. Learned counsel entered appearance on behalf of respondent 1, 2, and 3.
Only one.
Only one.
Respondent number 1.
Appears for respondent number 1. Next para office note dated 22/11/2024 reflects that service report in respect of respondent 2 and 3 has not been received back. List the matter after 3 weeks.
2 weeks, my lord. I will file affidavit. I have served a copy, my
Two
lord.
weeks, huh?
Obviously.
May I please, Lordship?
Yes.
Your Lordship, we have taken first step against respondent number 2 and 3.
Respondent number 12.
2 and 3.
2 and 3.
Huh?
2 and 3.
2 and 3.
When? Has not yet taken steps for situation notices and respondent 2 and 3.
Yes. I have informed that they have taken.
Who?
The leading counsel K lawyer. I have instructed to 6
Heard Mr.
M. Ratan on behalf of K lawyer.
Learned counsel for the petitioner appearing on behalf of Mr. K lawyer, learned counsel for the petitioner submits that they have taken, he has, the petitioners has taken steps for service of notice upon respondent number 2 and 3. List the matter after 3 weeks. You are for?
My lord, I'm for the respondent number 1.
Oh, Mr. So-and-so, learned counsel for respondent number 1 is present.
My lord, interim is there, interim.
Interim order pass, let's continue.
19, Your Lordship.
Huh? 19?
19 service is awaited for respondent number 2.
Ever service report in respect of respondent number 2.
2 years.
This after 4 weeks.
Deeply office.
Yes.
My lordship. Lordship, on the last occasion, TCR was called, lordship, trial court record. Just before the moment, lordship, I have heard the TCR that is incomplete, lordship. So complete record may be called, lordship.
Is it?
Yes, lordship. It is plain written statement, lordship. Rejoinder and my objection has not been.
Elbam, learned counsel for the petitioner. And Mr. Elbam, learned counsel for the petitioner, and also, and Mr. Jita, learned counsel for the respondent. It's all respondent.
All respondents.
All the respondents. Come on. It is informed that, no, it is submitted that the trial court records which has been received is incomplete. Mr. The registry to call for the complete records. List after 4 weeks.
Lordship, there is interim.
Interim order to earlier said continue.
Deeply obliged.
Well, Lordship.
Yes.
Lordship, I'm very sorry to inform this court that in this case, we are supposed to take a step, Lordship. However, we couldn't make it. Lordship, so
On the
I
prayer
made
of Mr.
Keado.
Keado, learned counsel for the petitioner. No, Mr. Keado, learned counsel for the petitioner is granted further 3 days time to take steps for service of notice upon respondent number
22.
for service of notice upon the sole respondent. The registry to issue notice on being filing of requisite notice for services, list the matter after
Lordship, there
4
is,
weeks.
Lordship, there is an interim.
Interim order pass earlier shall continue. 24. No, it's already. Okay, then we'll take it about. Right, too.
This is my lord, all matter, 2019 matter. Kindly, if it can be disposed of today.
Hmm.
In this case, my lord, I am issuing the impugned judgment dated 7/8/2019, passed by the learned CGM UPA, wherein, my lord, despite of my lord clear and urgent evidences, the respondent, he was acquitted, my lord. So accordingly, we have filed also a criminal leave petition that was allowed on 13 September 2023. Thereafter, this appeal petition.
Who is for
other side, amicus is there.
I'll be representing the respondent as amicus curiae.
Ronbil Yangpo?
Yes,
my lord.
Yes, your lord.
138.
138. Amount is also, my lord, 5 lakhs, and then transaction that was taken place in the year 2012. Thereafter, 2016, he agreed and he issued the check of rupees 5 lakhs by adjusting the interest amount whatsoever, by arranging some mediator. He agreed, signed, not disputed, check issued to me, not disputed, but only the concern of learned CGM UPA was that since my relation with the respondent was not cordial, in the last some panchayat election, my husband and he was in opposition. So those things had taken into consideration. Since our relation, it was not cordial, and since there is no any agreement of transaction while paying the amount, and in fact, the amount was not paid directly by me to the respondent. It was paid through CW3. One lady is there, and he knew it, that amount belongs to me, but then he directly did not approach me. But 2016, he agreed. We have arranged the mediator. Accordingly, check it was issued. Everything is proved. And as my lord knows it well, that law section 118 and 139 of NI Act, that presumption, my lord, that is in my favor. And to that effect, how that cannot be applied in this case, that was not justified by the learned CGM. For that particularly, my lord, may I kindly directly take you to paragraph 5 of my petition, my lord, wherein I have elaborately stated the findings, the regions, at page 5 only, my lord. That the learned CJM UP, after considering the evidence adduced by the parties, has made the following points for determination. Number one, whether the accused issued the check number 756093 dated 11/5/2016 in favor of the complainant, one part, and whether it was issued for the discharge of legally enforceable debt or liability, that is on other part. Now, very interestingly, the London CJM UPI has arrived at the conclusion and finding that the check number 756093 dated 11/5/2016 was issued by the accused in favor of the complainant, thereby relying on the evidence of CW2 and CW4, before whom the accused has drawn the check by putting his signature, amount, and the name of the complainant. Evidence of CW2 is emphasized. CW2 was the mediator in between complainant and the accused, and the interest upon the loan amount was settled at 4% lump sum by the parties in his presence in the previous night of the day when check by number so and so was handed over by the accused for complainant in his residence. On the other part, that is, whether the check was issued for legally enforceable debt or liability, the learned CJM UPI has arrived at the conclusion and finding that, as per the evidence on record, the relationship between the accused and the complainant was not cordial. There is no any retained money loan agreement or money received. The loan amount was not directly paid by the complainant to the accused, and the same was paid through CW3 to accused. And in the complainant's petition, amount is reflected as rupees 1,50,000. But in the cross-examination of the complainant, she stated that the loan amount is rupees 1,40,000. Therefore, it was held by the learned CJM UPR that the said check was not issued to the complainant for the discharge of legally enforceable debt or liability, and respondent cannot be held guilty of offense attracting punishment under Section 138 of Negotiable Instrument Act. Now, the big questions remain unanswered by the learned CJM UPI is that in the absence of any defense witness on record rebuting the case of prosecution, if the check was issued in favor of the complainant by the accused proved not for legally enforceable debt and liability, it was issued by the respondent to the complainant for what purpose? That was not justified, my lord. Now, second, that question it was formulated is whether the check was dishonored for insufficiency of fund in the account of accused. This point was determined affirmative in my favor. Third, also, whether accused received the demand notice issued by the complainant regarding the dishonor of said check. This point was also determined affirmative in my favor. Whether the accused has failed to repay the check amount to the complainant within the stipulated period. This point also determined affirmative in my favor. Fifth, whether the accused has committed the offense under Section 130 of the Negotiable Instrument Act 1881. This point was determined negative by holding that the prosecution has failed to prove the existence of legally enforceable debt or liability of the accused towards the complainant. Thus, the learned CJM UPI by this order that this so and so has acquitted the accused respondent from the charge of offense punishable under Section 130 of NIA. So these small issues, my lord. Otherwise, the question formulated 90% is in my favor. Check not disputed, signature not disputed. In view of that, my lord, I'll put only one citation, my lord.
Let us read the judgment.
Judgment, my lord. That is at page 48, my lord. It starts from 49. May I read, my lord? This is a case instituted under Section 138 of the Negotiable Instrument Act 1881. The brief fact of the case is that on 10/2/2012, the complainant had given a loan amount of rupees 1,50,000 only to the accused person, with conditions to return the amount with 10% interest per month. The loan money was to the accused. The loan money was given to the accused through Kongyang Yangpo, CW3, on behalf of the accused. That the accused on 11/5/2016 issued a check bearing number 756093 in the name of the plaintiff for an amount of rupees 5 lakhs only drawn on SBI SEPA branch for discharge of the loan amount. The said check was presented for encashment on two dates, that is on 12/5/2016 and 13/5/2016. But on both the dates, the check was returned as unfair dishonor for reasons fund insufficient by return memo number so and so, so and so. On 16/5/2016, the complainant sent demand notice through his counsel and called upon the accused to make payment of the amount of the check in question within 15 days of receipt of the demand notice. The demand notice was served to the accused through registered post and dusty service. The accused failed to make the payment despite service of notice, and therefore the complainant filed this complaint case against accused person for the offence under section 138 NI Act. To prove her case, the complainant has examined herself as CW1 by way of affidavit and relied upon the following documents: check number so and so, return memo number so and so, exhibit 1, 2, and return memo number so and so, exhibit 3. Demand notice dated 16/5/2016, exhibit 4, and postal receipt as exhibit 4-1. 5. On finding a prima facie case against the accused, he was summoned by order dated 6/6/2016. Consequent to the service of someone, the accused entered appearance and was admitted to bail the same day, that is on 7/9/2016. The substance of the offence was explained to the accused, to which he pleaded not guilty and claimed trial. During the trial, complainant adduced evidence of complainant witnesses, namely Nikpu Yangpo, CW2, Tanyang Yangpo, CW4, Pungyang Yangpo, CW3, Narendranath Saha, CW5. Subsequently, the accused was granted a right to cross-examine the complainant and his witnesses. The complainant evidence was closed by order dated 5/2017. On closure of the complainant evidence, statement of the accused was recorded under section 313 CRPC, and all the incriminating circumstances were put to him to offer an explanation. Then the matter was listed for defense evidence. Despite of granting time to adduce defense witnesses, the defense did not lead any evidence and filed a misapplication by number so and so, wherein the accused disputed his signature in the check dated 11/5/2016 and fled for sending a same for expert examination. Accordingly, to afford opportunity to the accused, documents including the original account opening from form were also called from the SBI SEPA branch. The question document along with admitted handwriting and signature were sent to Forensic Science Laboratory FSL Bandar for examination by order dated 26/11/2018. The report from the FSL was received on 4/2/2019. On perusal of the FSL report, it appears that no any opinion could be formed on the disputed signature, as there was no admitted handwriting sent for examination was not adequate for expert examination. The defense evidence was closed by order dated 11/3/2019. Final arguments have been heard on behalf of both the parties. The submission made on behalf of both the parties have been considered, and record of case has been thoroughly perused. In order to ascertain whether the accused has committed the offence under 138 of NI Act, it is deemed fit to examine separately as to whether all the indispensable ingredients constituting the offence have been proved by the complainant. Accordingly, I have framed the following points for determination in order to arrive at the definite finding to case. Number 1, whether the accused issued the check bearing number so and so dated 11/5/2016 in favor of the complainant for the discharge of legally enforceable debt or liability. Number 2, whether the check was dishonored for insufficient fund in the account of the accused. Number 3, whether the accused received the demand notice issued by the complainant regarding the dishonor of the check. Number 4, whether the accused has failed to repay the check amount to the complainant within the stipulated period. Number 5, whether the accused has committed the offence under 138 NI Act. Discussion, decision, and reasons thereof. Point for determination number 1, whether the accused issued the check number 756093 dated 11/5/2006 in favor of the complainant for the discharge of legally enforceable debt or liability. Para 10, the complainant in support of her case adduced her evidence as CW1. She deposed that on 10/2/2012, the complainant had given a loan amount of rupees 1,50,000 only to the accused person with condition to return the amount with 10% interest per month. The loan money was to the accused through Kongyam Yampo on behalf of the accused. The complainant has adduced the evidence of Kongyam Yampo as CW3. She deposed that accused asked her to lend him some money. As she did not have any money, she arranged money from Yasi Yangpo, that is complainant, and had given rupees 1,40,000 to accused. The same was corroborated by the CW4, husband of the CW3, and CW4 deposed that his wife CW3 took loan from Yasi Yangpo and gave it to Ranmir Yangpo, that is accused, and complainant demanded the loan amount from his wife, that is CW3.
The issue is issue number 1 only. Whether there is a whether the check is issued in favor of the complainant is for discharge of legal enforceable liability.
Therefore, I have written, my lord.
Yes.
It is in two parts. One is whether issued, that is affirmative. But whether it was for
Issuance is it has been proved.
it has been
Signature
proved.
is also proved.
Down below, yes, it has been proved.
Only issue is the acquittal is on the basis that there is no legally enforceable liability.
My lord. Yes.
That
Yes,
part,
because my lord.
that part you come.
Yes, because my lord, they are not denying that they have not taken the amount. In fact, in between to my understanding, to delay the trial, they have disputed their signature. But then that was also not taken into consideration, and that order they have never challenged before any higher forum. So now, my lord, the learned defense counsel argues that there is no any legally enforceable debt against the accused, as the complainant could not produce any document to show that the accused had taken loan from her. On the other hand, learned counsel for the complainant submits that under section 139 of the NI Act, there is a statutory presumption in favor of the holder of the check that the check was issued for the discharge of legally enforceable debt unless contrary is proved. He further submits that the accused could not produce any evidence even after given several days for defense witnesses. Para 11. After the closure of defense evidence, the defense contends that the signature in the check is not his and prayed for sending the same for expert opinion to forensic science laboratory. Accordingly, admitted handwriting and question documents were sent to FSL Bandra for opinion, but no opinion could be gathered on the disputed signature as there was no admitted handwriting retained by the accused before the date of execution of question document. The defense evidence was closed by the order dated 11/3/2019. Paragraph 12. The defense did not press for further sending of documents for examination and hence case was fixed for argument. 13. Learned counsel for the complainant submits that during the stage of prosecution evidence, the defense did not raise any dispute on the signature in the check. As such, no cross was also made in this regard. And just to delay the matter, they have sent the documents for FSL examination. He further submits that if the signature was forged, then the bank would have returned the check with the reason that signature differs, but the check was returned due to insufficient fund. Paragraph 14. I have heard the learned defense counsel and perused the evidences. CW2 deposed that accused and his wife came to his house with the check and put his signature in the check. CW4 also deposed that accused took them to the house of Niku Yangpo and drawn a check in his presence and handed over the same to Niku Yangpo. CW4 has also identified the check in the court. The complainant has proved the signature in the check by adducing oral evidence. It is affirmative in my favor. 15. Learned counsel for the complainant has also placed reliance on the Honorable Supreme Court judgment in Dayal Singh and other versus so and so reported in 2012 at SCC. I have gone through the judgment as no expert opinion could be gathered on the signature of the accused. The present judgment is not applicable to this case. As the accused assert that signature in the check was not his, the onus of proof is shifted on him to prove the same. The defense did not press for sending the document for examination for second time, as no opinion was formed on the earlier one. Otherwise, the accused could have proved the signature through adducing evidence of the branch manager of SBI Bank where his account is maintained. In the 313 statement also, accused did not deny his signature on the check. 17. Coming to the question whether the evidence on record is sufficient to prove that signature in the check is that of the accused, let me appreciate the evidence on record. In absence of the expert opinion, CW2 deposed that accused and his wife came to his house with the check and put his signature in the check. CW4 also deposed that accused took them to the house of Niku Yangpo and drawn a check in his presence and handed over the same to Niku Yangpo. CW4 has also identified the check in the court. I have also carefully perused the signature in the check and account opening application form of the accused, which was called from SBI SEPA branch, and also the signature put in statement under section 313 CRPC. On comparing the three signatures, I find the speed and pattern of the signatures are same and line in all the signature is below the signature. I have also perused the admitted specimen signature written at the time of sending the documents to FSA. On careful perusal, it appears that the specimen signature is different from aforesaid signature, and line in the signature is also in the middle of signature. In my opinion, the accused has consciously signed the signature knowing that same would be sending for examination. As per Section 73 of Evidence Act, court can form opinion by comparing the admitted handwriting signature and specimen handwriting made before him. In a so-and-so case reported in 1994 Supplementary 2 SEC 619, the Supreme Court has observed that handwriting may be proved on admission of the writer or by evidence of some witness in whose presence it was written, and that this is to be termed as direct evidence. In absence of such direct evidence, opinion of the expert or of someone who is familiar with the writing of the person. It is also observed that the third method is provided by Section 73 of Evidence Act, and that comparison by the court with the writing made in the presence of the court or admitted or proved to be writing of the person may also be done. 19 my lord. Hence, the signature of the accused is proved from the evidence of CW2, in whose presence accused put his signature in the check, and also material on record before the court, which includes the account opening application form of the accused, the question check, and the signature in the statement under Section 3 on. So this all went in my favor, my lord. Paragraph 20, my lord. Once the signature in the check is proved to be of accused under Section 139 NI Act, it is presumed that the check pertained to a legally enforceable debt or liability. This presumption is of a rebuttable nature, and onus is on the accused to rebut. Now let me decide it if there is any legally enforceable debt in favor of the complainant. Complainant adduced Hassel as CW1. She deposed that the accused issued a check bearing number so-and-so, dated so-and-so, for ₹5 lakhs to the complainant, but the same was dishonored due to insufficiency of funds. In our cross-examination, the complainant deposed that he knows the accused person as he is from her village, and accused is the Anchal chairman since 2012. She further deposed that she did not support the accused during election, my lord. This is very important. I did not support the accused during the election. The accused had earlier quarrel with her husband, my husband, Chungma Yangpo, for money transaction. Complainant further deposed that the loan amount of ₹1,40,000 was given to the accused through her auntie on her behalf, that is CW3. The check, that is Exhibit 1, was also not issued to her, and she does not know who has written her name and amount in the check. The complainant has received the check from the wife of Niku Yangpo, namely Yanang Yangpo. She also stated that one Niku Yangpo, Punyang Yangpo, Taram Yangpo, and Tanyang Yangpo were present at the time of transaction. It is not believable that complainant would lend money to accused when she did not support the accused in his election during 2012. Here is the crux, my lord. And also, when her husband had a fight with the accused for money transaction. So this drawn the inference that since my relation with the accused, it was not cordial, so there is no any possibility that I should lend money to him. The complainant deposed that since 2012, accused was Anchal chairman, and in her complaint petition, she has stated that money was lent in the year 2012. As she has not supported the accused in the election in the 2012, that means there was no any cordial relation between the accused person and the complainant, and it is not believable that in the same year, that is 2012, complainant lent money to accused, that also without executing any document. However, my lord, the point to be noted herein is that that issue is already settled. As because considering that he had taken the amount, therefore mediator has subsequently come in the year 2016, and that interest amount that was settled, thereafter 5 lakhs check it was issued. CW2 deposed in his cross-examination that accused took him to the house of complainant as accused did not know the house of the complainant. If accused had a close relationship with the complainant, then he would certainly have known the house of the complainant. From the statement of complainant and CW2, it is clear that there was no close and important relationship between the complainant and accused person, and it is not believable that complainant would lend money to accused through another person without executing any agreement or promissory note. There was no direct transaction between the accused as complainant admitted that loan amount was paid through her aunt to the accused, and the check was handed over to the complainant by one Yanang Yangpo. The complainant has not adduced the evidence of Yanang Yangpo. The complainant had stated in her complaint petition that the loan amount was rupees 1,50,000 to the given to the accused with agreed terms and condition to return the same with 10% interest per month. But the complainant has not produced any agreement promissory note, or she has mentioned the date on which the loan was given. The amount is also mentioned as 1,40,000 in her cross-examination, which creates a doubt on her statement. It is not possible that any prudent man would lend money to anyone not close to him without executing a document. However, as per the statement of CW4, my lord, in the evidence, he has stated there is no agreement in the transaction as because we are from same clan. That is at page 43, my lord, in the evidence. Now, paragraph 21, my lord. CW3 deposed that accused asked her to lend him some money. As she was not having any money, she managed the money from complainant, and complainant gave her an amount of rupees 1,40,000, which she had handed over to accused Ranmini Yangpo, that is respondent. She further deposed that when the check given by accused to complainant got bounced, the complainant demanded the money from her. In her cross, she deposed that check was handed to complainant by Niku Yangpo. It appears that while giving the loan amount to accused, CW3 also did not execute any document to prove that she had in fact given the money to accused. The demanding of money from CW3 by the complainant also creates a doubt, as it is not stated clearly if the money was taken from complainant specifically for accused, or CW3 took the money and again lent it to accused. Otherwise, the complainant would not have demanded money from CW3. The non-execution of any agreement received creates doubt about the transaction between the accused, complainant, and CW3. 22. CW2 deposed that there was talk of compromise going on. Accused and his wife came to his house with a check, and accused put his signature and date in the check, was also put as per the instruction of the accused. But in his cross-examination, he stated that accused asked complainant to put the date on the check, and complainant might have put date on the check. The evidence of CW2 is contradictory with the statement of the complainant. Complainant deposed that check was handed over to her by wife of CW2. The complainant did not depose that accused was present during the time of handing over of the check. CW4 deposed that her wife, that is CW3, took loan from complainant for accused, and the complainant was demanding loan from his wife as accused did not return the amount. So they sit together to settle the matter. Next, the accused took him and his wife to the house of Niku Yongpo and had drawn the check in his presence. He further deposed that accused told them that he would pay the money within 30th April, and if failed, to put the date on the check and withdraw the amount. It shows that accused himself did not put the date on the check. The statement of CW2 and CW4 is contradictory and hence cannot be relied upon. The complainant witnesses also did not state that the complainant was also participated in the settlement meeting. The presence of complainant was material as the money was advanced by her. The non-presence of the complainant also casts a doubt that CW3 might have taken loan from the complainant and again lent it to the accused person. 23. Learned counsel for the complainant contends that accused fails to produce any evidence to rebut the presumption, nor he has elicited anything against the complainant by cross-examining the CWs. I am not consented to the contention made by the learned counsel for the complainant, as the prosecution has to stand on its own feet and cannot take advantage of the weakness of the defense. The standard of proof of the accused person in NI Act case is preponderance of probability. The lack of legally enforceable debt need not be proved beyond reasonable doubt. In case of Kumar Export versus so-and-so, reported in so-and-so, the Honorable Supreme Court held that to rebut the statutory presumption, an accused is not expected to prove his defense beyond reasonable doubt, as it is expected of the complainant in a criminal trial. That is, my lord, not disputed, that legal proposition. 25. The defense has not adduced any evidence to rebut the presumption against the accused. However, the accused can rebut the same by material on records or evidence brought by the complainant. The Honorable Supreme Court in so-and-so has held that in the absence of compelling justification, reverse owners usually impose an evidentiary burden and not a persuasive burden. Keeping this in view, it is settled position that when an accused has to review presumption under section 139. The standard of proof of probability. Therefore, if the accused is able to raise probable defense, which creates doubt about the existence of a legally enforceable debt or liability, the prosecution can fail. As described in the citations, the accused can rely on the material submitted by the complainant in order to raise such a defense, and it is conceivable that in some cases, accused may not need to adduce evidence of his or her own. So these are the observation, my lord. But then that presumption, my lord, the law that gives presumption that if I am the holder of the check, if the signature is proved, issuance of check is proved, bouncing of check is proved, then onus shift on the other side, on the accused, to disprove it. But then in this case, even 313, he has said nothing, that 2012, I have not taken money. And 2016, that check, it was not issued by me. That signature does not belong to me. Signature, of course, he disputed, but that prolonged, like sending the signatures. Thereafter, rightly, to my humble understanding, London Trial Court below invokes Section 73 of Indian Evidence Act and form its own opinion that this signature belonged to the accused person.
What you have to show is that there is a legally enforceable debt.
That one very good judgment, directly applicable photo in our case, because in that case also no evidence it was laid. Even 313 silent.
Your deposition says that you have not directly lent the money to the accused.
Correct, my lord.
It was through somebody.
Throw somebody. Because that lady, who is my aunt, in her deposition, she said that this accused person approached her for lending some money.
She doesn't have money, therefore she asked it from the complainant.
Since she was not having money, then she asked from me. So accordingly, I have faith.
To whom the check was issued?
Check was issued in my name. Therefore, my lord, I am saying 2012 chapter is closed now. 12 who has given whom, it was given through whom, that is closed as and when 2016 we have set for settlement, and then 10%, earlier it was 10% per month, that was lump sum settled at 4%, and then considering that all the members who were present there, mediators, they have settled at rupees 5 lakhs. So accordingly 5 lakhs checks, it was issued in my name. So check is in my favor. That is affirmative as per the London Trial Court.
Let's see the judge.
Uttam Ram's case, my lord. Paragraph 18 to 34. Uh, 2019. Paragraph 18 to 34. Paragraph 18 to 34, my lord. Elaborately discussed, my lord. May I read, or it will be. The best one is 26, paragraph 26. '18 onwards, the reiterated some of the judgments previously it was decided. 26 is the finding. like my lord 26.2, the statement of the appellant as CW2 that the check was handed over by the respondent personally remains unchallenged. When it says my lord unchallenged, that
Where,
is paragraph 26.2. May I read 26, my lord, in that case? 26 it says, my lord, in view of the judgments reported to above, we find that the respondent has not rebutted the presumption of consideration in issuing the check on 2/10/2011, inter alia for the following reasons. 26.1, statement of CW2 that he is not an agent of the respondent has not been challenged by the respondent in the cross-examination. Here in my case, it will be, my lord, that lady CW3, you have not given the amount by taking it from the complainant. That was not put to in the cross-examination. That question it was not put, and it was not proved also. 26.2, my lord. The statement of the appellant as CW2 that the check was handed over by the respondent personally remains unchallenged. So unchallenged means, my lord, here you have not put it any questions during the cross-examination, and connecting that question, you have not adduced any defense evidence. 26.3, the respondent has not denied even in his statement that the check was not issued by him. That is in 313. The cross-examination of the witnesses produced by the appellant also does not show that the signature on the check by him have not been disputed. 26.4, the respondent relies upon every recorded with the police on so and so. So these are the finding, my lord. And one judgment, learned trial court below relied, my lord, that even in the absence of defense evidence, my lord, on consideration of the material available with the prosecution, the trial court can infer some material that is favorable to defense. That is in paragraph 9, this judgment, my lord. It says, the learned counsel for the respondent has referred to the judgment of MS Narayanan Menon so and so, in our case also, that evidence adduced by the complainant can be relied upon to rebut the presumption of consideration. However, the said judgment has no applicability to the facts of the present case, as the trial court has found that the presumption is not rebuted, but still the trial court dismissed the complaint for the reason that the appellant has failed to prove the amount mentioned in the check as due amount. Once the check is proved to be issued, it carries statutory presumption of consideration. Then the onus is on the respondent to disprove the presumption at which the respondent has miserably failed. So in our case also, my lord, maybe he's having very good case, my lord, accused. But at least when law drawn a presumption in my favor, so to rebut that, at least he has to adduce the evidences, defense evidences. And he has even not put any cross question, my lord. Even to bring on tomorrow, like defense witnesses, my lord, initially there should be question to the prosecution witnesses, challenging his evidences.
There is no cross, nothing.
Cross is there, but then no cross that money was not taken in the year 2012. Nothing as such.
Okay.
Leaving aside one finding, 90% is in my favor.
No, after even if proof of issuance of the check and the signature, everything, only acquittal is on the basis of that there is no transaction, which is said to be a legally enforceable debt.
My lord,
That
in
is
the year
only-
2012, no money received. Since their relation, it is not cordial. Election enmity.
There could not have been any enforceable debt.
There could not have been any transaction in the year 2012. Now, when we have
So
arrived at
according to you, once the issuance of the check
yes, my lord,
is proved,
proved, my lord.
there is no question of having a legally enforceable debt.
My lord, that has to be reviewed through the cogent evidence by the defense, my lord. That has not done in this case. That's all, my lord. Highly appreciate.
Your Lordship has rightly pointed out that to punish the alleged accused under Section 138 of Negotiable Instrument Act, the primary issue that has to be established is what your Lordship has rightly pointed out, that there has to be a legally enforceable debt that they have failed to establish, Lordship. Lordship may kindly come to para 26. I'll just reiterate what my learned elder brother has read out.
Of this
Judgment.
judgment.
Judgment, Lordship, page 58, Lord.
58.
58. Paragraph 26.
Yes.
Page 59.
It's 58.
59.
59.
It's 58.
In my
There are two
in my petition, it's
page numbers.
58.
It's 58.
In my 50.
Page 58.
Right.
In the instant case, the complainant fails to prove any financial transaction between both the parties. The complainant has not even mentioned the date on which liability accrued. The complainant also could not show that she had a close relationship with the accused so as to advance the loan on friendly terms without executing any agreement, promissory note. In fact, the loan amount was paid to the accused through one Kungyam Yangpo, and the exhibit 1 check was handed over to the complainant by one Yanam Yangpo. There is no any documents to show that accused had taken loan from complainant or by Kungyam Yangpo. Hence, accused is able to raise a probable defense which creates doubt about the existence of a legally enforceable debt. Defense has able to rebut the presumption of legal liability, and the complaint has failed to prove the same affirmatively. In view of the above discussion, it is hereby held that check number so-and-so, dated so-and-so, was not issued by the accused in the discharge of his legally enforceable debt or liability. Now, Lordship, I have a citation of High Court of Delhi, whereby this section 38 and 39, 139, has been clearly dealt and explained. I'll just refer one paragraph of this judgment. SEC, Supreme Today. I have printed it from Supreme Today.
Yes.
Paragraph, Lordship will see paragraph 10. Here, section 138 and section 139, the whole section has been reproduced. Now, after going through these particular sections, paragraph 12, it has summarized what is there in section 138 and 139. I'm reading para 12, Lordship. The explanation appended to section 138 explains the meaning of the expression debt or other liability. For the purpose of section 138, this expression means a legally enforceable debt or other liability. Section 138 treats dishonored check as an offense if the check has been issued in discharge of any debt or liabilities, other liability. The explanation leaves no manner of doubt that to attract an offense under section 138, there should be legally enforceable debt or other liability subsisting on the date of withdrawal of the check. In other words, withdrawal of the check in discharge of existing or past adjudicated liabilities signed on for bringing an offense under section 1. So relying on this, Your Lordship, the learned court below has rightly acquitted the alleged accused in the instant case, Lordship. Now here the complainant has
It
miserably
is
paid.
not only the mere issuance of check or proof of the issuance of the check
Yes.
of this or not. It has to be for the legally enforceable debt.
Debt, yes.
It
Debt they
has
have
to be issued for legally enforceable debt.
debt.
Otherwise, it is incomplete.
Incomplete.
There
yes.
cannot be an offense.
It cannot. On that basis, the alleged accused was acquitted. So my humble submission is there is no infirmity in the judgment passed by the CDM. So this criminal appeal is liable for dismissal. Same issue was raised in this judgment, Lordship. Same type of issue.
Just only one clarification, my lord.
Yes.
Only one clarification on legal aspect only. The judgment which I have relied, that elaborately has discussed, and leaving aside that, my lord, what 139 says, my lord. Once check is issued, not disputed, it is in my favor. What is the presumption? That it was issued because there was legally some debt was there. Therefore, that check it was issued.
But you have to show that, you have to prove that
We
there
have-
was a legally enforceable debt.
We have proved it, my lord. 2016 debt settlement, because whatever learned court below is saying is of 2012.
It's not only debt, it's a legally enforceable debt.
Correct, my lord. Because amount it was taken, all my witnesses are saying that CW3, my aunt, she is the main person. He said, accused asked me money, but then since I was not having money, so I take it from complainant, from me, and given to him. And that part was discussed in 2016 in the settlement with mediator. Accordingly, it was settled, interest portion also from 10%, lump sum 4%, it was reduced. And then on agreed, that check of rupees 5 lakhs, it was issued in my favor.
Is there any definition of legally enforceable debt under the NI Act? Any particular definition?
Specifically, it in
you try to find what is the meaning of legally enforceable debt. NI Act. Negotiable instrument.
that must be in some judgment, my lord. But in language of 139, my lord, merit, it shall be presumed, unless the contrary is proved, that the holder of a check received a check of the nature referred to in section 138 for the discharge in whole in part of any debt or other liability. This legal presumption is there, my lord. Therefore, my lord, I am saying once I have been issued with the check, then there is a presumption that it was issued to me in discharge of debt or other liability. And kindly also see 118, my lord. Presumption as to negotiable instruments. One 118, my lord.
Sweet.
If my lord has seen 139, then kindly see 138, last explanation, my lord. For the purpose of this section, debt of other liability means a legally enforceable debt or other liability, my lord. And this other liability has been referred to in section 139. 139, my lord. Kindly now read 139, my lord. Last, my lord. Whole or in part of any debt or other liability, my lord. The presumption, my lord.
Yes. Or Mr. K. Thama, Learned Counsel for the appellant.
Appellant, my lord.
And also Mr. J. Learned Additional, Learned Amicus.
Amicus.
Hearing concluded. Order reserved.
Hello.
Look
Problem.
into it. Yes. We will take this also.
May I, Lordship? I'm for the appellant, Lordship.
Yes.
This is a MAC appeal, Lordship, whereby we have challenged the impugned judgment and award dated 04/06/2022 passed by the learned court below. So, Lordship, I have only limited prayer before this humble court. Case may be remanded back to the learned court below for settlement of fresh issue. Whether the owner of the vehicle or an insurance company is liable to pay compensation to the claimant, Lordship. Because at the time of incidents, LS incidents, the vehicle is duly insured with the insurance company, Lordship. So, Lordship, may I take Annexure 6, Lordship, in my appeal petition,
Yes, go ahead.
page 54, Lordship. This is an insurance policy, Lordship. At the time of the LS incidents, we have a appellant have a active policy, Lordship. But same was not appreciated by the material evidence was not appreciated by the learned court below. Then directly come into the conclusion that the owner of the vehicle is liable to pay a compensation as claimed by the claimant, Lordship. Because, Lordship, learned court below come into the conclusion that the person involved in
the claimant, claimant is the father of the deceased person.
Who are you, appellant?
I am an owner of the vehicle.
Yes.
So I'm challenging this impugned judgment and award, saying that I am not liable to pay. If any person is liable to pay to the claimant, it's an insurance company, Lordship. Because at the time of the alleged incidents, I have a active policy, Lordship. That is a package policy, Lordship, which is a exclusive policy, which covers the entire risks, including the owner driver Lordship. But same was not appreciated, and entire record was not foreseen by the learned court below, has made a manifest error and come into the conclusion that the owner of the vehicle is liable to pay the compensation as claimed by the claimant, Lordship. So my limited prayer, Lordship, does maybe remand back to the learned court below for issue phrase settlement of the issue, Lordship.
There's no liability against the insurance company.
Yes. Because is any person is liable to pay. My vehicle was insured, Lordship, during the incidents, Lordship.
What is the
Insurance
what is the issues?
Issues is
Page number 18.
Page number 18 years.
Yes. What is the findings? What is the other issues has no problem.
No, Your Honor.
Only the
Only the issue number 2, Lordship.
fixing of liability either to the
Yes.
you or the appellant.
Insurance company.
Insurance
company.
And what is the finding of issue number 2?
Lordship, that is at page number 29. Para 34.
29 or 30? Para?
34.
Para 34.
Yes, page number 29, para 34.
Non-factor issues what has two brought into one is sexual liability for this other condition. Before the vehicle is planned for the potential. What is the finding? This is the finding.
Yes, Roshi will see the first para of page number 30. Then observation, if I may read one. At the OP number 2, that the owner avail the premium.
Which one?
First para, fourth line. First para, page number 30.
Had the OP and number 2 avail this.
That is there. The court has categorically observed that they have not paid the premium, so that they are liable. So, in my humble understanding, my lord, they have to satisfy my lord that whether the learned tribunal had made an error in appreciating that they had indeed paid the payment. That is the only issue to be adjudicated.
Had the OP number 2. You are OP number 2.
Yes.
You are OP number 2.
Yes, sir.
Avail the premium of legal liability to the driver. The liability would have been shifted to OP number 1. Without doing so, the OP number has taken the responsibility of the risk and thereby his liability. Yeah. Show us.
Ensure the discussion yourself.
No,
May I
show us
please?
whether you have availed the premium of legal
Yes, come to the page number 58, Lordship.
58.
Is 58 years. In the first column, Lordship. We have duly paid, Your Lordship.
58.
Yes, page number 58. In the first column.
What is this employed for?
This is additional liability to the person employed for operation and or maintenance and or loading and or unloading, which is paid, yourself. The person employed for operation, Lordship. He was the operator, yourself.
How do you, is it not placed before the tribunal?
The same was placed before the learned court below. Same was placed, Lordship, but same was not appreciated.
By your evidence?
Yes, Lordship.
Have you placed on record by adducing evidence?
Yes, Lordship.
Where it is? Where is your deposition?
We have not annexed the deposition.
And the written statement.
Written statement is, yeah, Lordship. Written statement.
Where have you said?
Sorry, Lordship, we have not annexed our written statement.
How do you know? Lordship, written statement is page number 38. 38.
47. 47. OP2. Of the period, 43. Written statement was reaching theory, OP number 2.
40?
Seven. Appeal.
Yes. Is there any?
Appeal number 48, they made a adjournment that the.
Is that the state extradition originally issued from the engines fully covered under the payments? Issued the amount of the accident in 2018. Para 7.
Yes.
And page number 28 of the judgment, the learned tribunal had discussed that why their plea was not considered. Para number 31. Page number 28.
28.
28. Para 31. This para the learned tribunal had discussed why they had considered.
Yes. Yes, what is your evidence?
My evidence. Lordship, in regard to the paragraph 31, Lordship, in response to that, we have page number 56 or 58, Your Lordship. This is the answer to this question, Your
So
Lordship.
have you placed that before the tribunal?
Yes, Your Lordship.
evidence. Give it to them. On page 58, it's very difficult to find out.
In the very first column, Lordship. This is a premium column, Lordship. This is a premium column, Lordship, that we have made a premium.
No, you show us where this was in place before the tribunal?
Lordship,
By-
so
by-
actually,
By
some-
adducing evidence.
some other council was presenting in the law.
May I, Lordship? Lordship, the annexes, they have annexed, Lordship, that page number 58. That was not placed before the tribunal. Just the insurance policy, the first page of the insurance policy was annexed.
No, what is this? Is evidence, deposition.
That is the.
Have you adduced evidence? This page 50 is not in the record. Is not it?
Yes, Lordship.
Yeah, Lordship, some other council was present
No,
in the
it's
learned
okay.
court below, he said.
You cannot blame them.
Yes,
No. If it was not there, it was not there.
but Lordship, the
No, it has to be, it's your page 58. is
insurance
not-
policy itself says it is a
It's
package
not in
policy.
the record.
Yes.
You have to adduce that before the tribunal. That these are the premium, these are the insurance policy, these are the premium you have paid. In appeal, when you are bringing on record, which has not been adduced before how the tribunal will know?
Because Lordship, the insurance policy itself says it's a package policy, Lordship. Package policy, it's.
Are you
expensive
getting me?
policy. Yes, yes, Lordship.
All this which you are submitting,
Yes,
you are saying that is despite payment of premium and other required
Yes.
policy, you have not, as per the policy, this has not been considered. When these things are not adduced before the by of evidence, if you have not adduced this evidence before the tribunal, how the tribunal will know that you have paid the premium and other thing?
That's
It
why
has
my-
to be placed before the.
Yes, Lordship, that's why my humble submission before this whole court, the phrase case may be remand back, Lordship, my humble prayer.
What is it?
So that
Death
the,
case?
so that the phrase issue may.
Death case, Lordship.
Death case.
And Lordship, this matter has been pending since 2022. It's coming for 24 now. So we are making a plea that this honorable board may adjudicate upon it, because it is a simple matter whether they have paid a premium or they have not paid premium. That is to be, if they, again, it is remanded back to the learned tribunal, Lordship, it will take time. Then again, the whole process will start. And then again, if live.
Only
Yes,
to-
you tell us. They
only
are
to
saying that
settle
they have
one
already
issue,
paid.
Lordship.
Yes, Lordship, with regard to the additional premium, there was the insurer, the Lordship, did not pay any additional premium, as it can be seen in page 51. Only the basic third party premium in the own damage OD claim, Lordship, OD premium, that was paid, Lordship. And beside the insurance policy of the terms and condition, Lordship, from page 56 to page 58, this term is IMT, Indian Motor Tariff. That was not placed before the tribunal.
No, according to whether they have paid it or not.
No, Lordship. No, Lordship. They have not paid. It can be seen in page 51, Lordship.
Lordship, may I, this is a RTI reply from the insurance company. Just to show the record that they have not denied, Lordship. Even though on the various occasions we have seek a time to file an objection, Lordship, but they have not even come with a written reply, Lordship, before this honorable court. The insurance companies failed to file any additional any affidavit in opposition, Lordship. Even though they have on the various occasions They have prayed for a file
LL
objection,
after
lordship.
deputy for carriage of more than 6 employees, excluding 2% employed for. Okay.
This is the RTR.
Basically, what do liability? How do we know this?
Lordship, in the first page, under question number 1, lordship, they have replied that the additional liabilities been paid, lordship.
For operation and maintenance and loading of sales was paid for. Certificate could be enclosed.
Yes, your lordship. This is the RTR reply from their authority, lordship.
Let's read the.
Lordship, that is with regard to the lordship. That is with regard to at page number 58. With regard to the good carriage, lordship. Since the involvement of loading and unloading is involved, lordship, that premium has been paid. However, the vehicle, lordship, the instant vehicle, accidental vehicle, was an excavator, lordship. Now the issue is that whether there was a good carriage vehicle, or an vehicle that was used for construction of road, lordship. That has to be seen, lordship. With regard to the additional liabilities for paid driver, lordship, paid driver, conductor, cleaner, employed for operation, that is not paid, lordship. Additional premium has not been paid with regard to that.
He said he has paid.
Lordship, that can be. Lordship, in the insurance policy itself, it says it didn't pay. They didn't pay the additional premium, lordship.
Where?
That is page 51.
And on RTA, you have said he has paid.
Lordship, that is with regard to the good carriers only. Now their RTA application, what kind of information they have seek, lordship, there has not been enclosed, lordship.
You bring it on record.
Okay.
And where's your stand?
Lordship, page 51.
What is your written statement?
Lordship, there is a
There's no deposition in this
page 51.
record.
No, lordship, with regard to this case, lordship, since the driver was the person that was involved in the accident, no third party was involved. Now the questions remain whether additional premium has been paid for the driver, whether the insurance policy covers the liabilities of the accidental death of the driver. That it has to be determined, lordship.
It's okay. He said he has paid. You have said you have not paid. We'd like to see whether that is the issue.
Yes, lordship.
You have to show that in the court, you have to, before the tribunal, you have to show that you have you should have adduced the evidence that it has not been paid. Where it is?
Lordship, it is in the insurance policy that the insurance.
Forget about insurance policy. It's a better
no,
paper.
lordship, no deposition was made, lordship.
Huh?
No deposition was.
No written statement.
Written statement has been given, lordship.
Where it is?
Page 41.
41.
Yes.
What does it say? Relevant para? Find out, is there any deposition? Any deposition was
No.
recorded?
Only one. The claimant himself was recorded.
That's all.
No one else.
Where it is?
Page
don't-
number 34.
I don't find a deposition also. In the record.
The record we will see, but in page number 34 of the judgment appendix, the learned tribunal has mentioned claimant witnesses and defense witnesses.
This original deposition I want. Otherwise, the use of having these records. I don't find any deposition of any witnesses. You are wrenching, Siri.
Yes.
Where's your You have not adduced any, no, you have not recorded any deposition, you have not filed an affidavit. Written statement is nothing on the issue. You are just disputing the challenge, the petition. You have not said that he has not paid any premium or that.
With regard to the violation of section 147 of the LBA, where additional premium is to pay for the employees beside the third party involvement of the party.
Where it is? Where you have said so?
There is a page 44, there are reviews
Of what?
of the legal statement. May I read, Lordship? That this answering opposite party is not liable for payment of compensation due to non-fulfillment of provision as laid down under section 147 of the Motor Vehicle Act. The owner of the vehicle is duty bound to prove this mandatory provision by producing all necessary documents in the tribunal.
So according to you, the premium which was supposed to be paid, he has not paid.
Yes, Lordship.
He has defaulted.
Yes, Lordship. Additional premium has to be paid in order to cover any person beside a third party, Lordship. Any person employed by the insurer. Now, since the driver, Lordship, was the only person that was involved in the accident, since no third party was involved. Now, the question, Lordship, here is that whether extra additional premium has been paid to cover the driver or not, Lordship. And in that regard, Lordship, the policy clearly says that no additional premium beside the third party.
Where it is? Where it is?
Lordship, page number 51. In the schedule of premium. In the fourth box, Lordship. Schedule of premium, Lordship. Basic TP cover. Liabilities. Liabilities, Lordship. In the schedule of premium. On the right side, Lordship, liabilities. Limited liability under WCA for carriers of more than 6 employees, excluding the driver, Lordship. To person employed for operation and or maintenance and loading and weight. This is not paid, Lordship. Only third party premium is paid.
How do you get it from? How do you read this? LL under WC for carriers of more than 6 employees.
Yes, Lordship.
To prepare employees for operation and or loading and all. How do you know that it's not been paid?
Lordship, if it is paid, then Lordship on the right hand side, Lordship. The additional premium, the paid additional premium would have been given, Lordship. However, on the bottom side, Lordship.
So this is the tribunal is based on this?
Yes, Lordship. Third party premium, TP premium is paid, Lordship.
Third party premium is paid?
Yes.
But
no additional premium.
So as per section 147.
Yes, Lordship. In order to hold the insurance company liable for compensation, Lordship, of any accident that occurs to the employees of the insurer, additional premium has to be paid, Lordship. It is mandatory, Lordship. Since it is a contract between the insurance company and the insurer to indemnify the insurer, Lordship. So additional premium, it is a necessary part of the insurance policy to pay, Lordship.
Lordship, my learned counsel friend is wrong here, Lordship. In the basic TP cover, Lordship, what risks is covered in the upper side, Lordship, and the premium is the below side, Lordship. Entire all those what risks is covered, Lordship.
58 indicates 58 indicates what? How much it is?
Is 50, Lordship.
58, page 58.
This is additional premium, Lordship.
How much?
This is 50, Lordship.
50 rupees?
Yes, 50 rupees. In the page number 51, in the what he's point out, Lordship. He is also wrong here, Lordship. How, Lordship? What basic third parties cover, Lordship? in the upper side is mentions of what basic covers, what types of risks is covered, lordship. In the below is the premium, T premium rupees 1,850 rupees, lordship.
It's very difficult.
This is for those covers, lordship. Third party risks, lordship. He's saying
We'll fix after 2 weeks. You just file your affidavit in that, and you also file your you clarify your stand by filing an affidavit. Lordship, whatever you may say, because it's very confusing because when you said it's been paid and he's relying on a affidavit, the RTA replies that it has been paid. So you explain what, Lordship. Explain it, we'll dispose of next day.
My lord, a small prayer.
Yes.
It will be after 1 week now.
Okay.
So after 2 weeks, it will again come to vacation. For after 1 week, then we can try to.
It's up to them. If they can.
Lordship, 2 weeks time, because Lordship, with regard to the additional premium, the IMT, Lordship, that has been produced in the appeal. Lordship, I may take instruction, Lordship.
That's what I'm saying.
Yes, written instruction, Lord.
You may file also affidavit.
Yes,
Additional
yes.
affidavit.
Yes.
Bring on record. Heard Mr. K. Tagyang,
T Bagang, lordship.
T. Bagang, learned counsel for the appellant. And also heard Mr. Geetala, learned counsel for the respondent oblique claimant. And Mr.
T. Tang,
learned counsel for respondent number 2,
Lordship.
insurance company. Let this matter be listed. Let the appeal be listed after 10 days. We'll say 10 days. 10 days. List of the respondent, the learned counsel for the appellant to file an additional affidavit, bringing on record the instruction, they bring on record the information obtained through RTA.
Yes, yes.
List with regard to payment of, what is that? Additional? With
Additional,
regard to payment of
additional liability to the
additional liability, is it called
Corporation.
additional liability?
Additional premium
person
for
employed.
Additional premium for
driver, Lordship, that can be
additional premium for driver, Lordship, public employee of the
insurer.
insurer.
Yes.
Please stop. The Mr. T. Tang also, the learned counsel for the respondent number 2 is also directed to file affidavit, bringing on record the stand of the insurance company as regard payment of payment of additional
premium, Lordship.
premium,
Yes.
as well as to clarify the distinction of premium paid to the premium paid for the third party as well as the employees,
Lordship.
or oblique driver of the insurer.
Lordship.
That will clarify whole thing. All right, and then we'll determine. Just after 10 days.
Obliged.
Otherwise, it's very difficult to, I mean, when there's a counter complaint and complaint,